this is CA Tejal Katariya, and with lots of energy, we are going to start with today's session. Today, we will be discussing mock test papers. And this video, we'll be discussing mock test 1, and the next video will be on mock test 2. Let's try to cover it as early as we can. We are going to discuss all the questions. I'll be focusing on case study based questions rather than direct questions, because you already know this is the question, this is the straightforward answer. So there is no complications in answering those type of questions. But yes, case law based questions are quite difficult to answer, so we'll be discussing all these questions. So first, let's start with the first question. The first question is, first A, Mr. Murthy was traveling to Manali with his wife by bus of Himalaya Travels Private Limited. Due to some technical defaults in the driver has to stop the bus in the midway in the cold night. Driver advised to the passengers to get the shelters in the nearest hotel at the distance which was approximately 1 kilometer from the place. Wife of Mr. Murthy caught cold and fell ill, and due to being asked to get down, and she had to walk the cold night to reach the hotel. So she is ill now. Mr. Murthy filed a suit against Himalaya Private Limited for the damages for the inconvenience, personal inconvenience, plus hotel charges, plus medical treatment for his wife. So explain whether Mr. Murthy would get that compensation for which he filed the suit, yes or no. So let's understand first the scenario, the facts. So this is the case law based question. If you are getting this question for 4 marks, so approximately you're supposed to answer like, first it should be the provision, then it should be the facts of the case or the explanation together, and the conclusion. If it would have been a 6 marks question, then you should write provision, then explanation, facts of the case, then explanation, and then conclusion for that. So let's start with the provision. So first of all, understand it's this question basically based on the Indian Contract Act 1872 and Indian Contract Act 1872, and the second thing which we should focus on is this question is based on basically damages. If you remember, we had a section. We learned section 73, which were all about damages, special damages or ordinary damages, vindictive damages, prefixed damages. We discussed all those damages. So now here understand they are asking for damages, but which damages they should get and which they should not get. We are focusing on that. So first of all, if you guys remember, so when it comes to the natural or ordinary damages or ordinary damages and special damages. So ordinary damages are those damages which you used to get in the natural course of business, or which is not because of indirect loss. And special damages are something where you were getting those damages because of you have suffered some indirect loss. So in this question also, you're supposed to understand the problem is that the bus was not okay. So that wife has to walk from the bus to the hotel, so approximately 1 kilometer. So it's inconvenience caused to her. So that's why you can claim for that. But because of that, she suffered and she got an cold and got ill, and all these things are indirect. So these are not something which is in the ordinary course of business. So what happens is, understand, according to section 73, the party who suffers by such breach is entitled to receive something from the party who broken the contract for the compensation for any loss or damages caused to him, which naturally arose in the usual course of the thing. So this line was very, very important. Which one? This naturally arose in the usual course of things from such breach, on which the parties knew when they made the contract to likely to result in a breach of it. But such compensation is not given for any remote or indirect loss. So this line is also important, that these damages, whenever the the party who is breaking the contract is not responsible for any of the indirect loss or any remote loss for any of the breach of the contract. So in this given case, who will be Who will be responsible? Mr. Murthy will be responsible, but he will be responsible only and only for the inconvenience caused to them, and not for any of the kind of indirect loss. So what happens in instant case? Mr. Murthy filed a suit against the travels for the damages, but on the basis of given provision, this provision. So understand, this was the provision part. Okay, this was basically the fact part, and this was the conclusion part. Okay, so you're supposed to understand how you should not write exactly what is given in the suggested. You should what you can say, divide all the entire answer in 3 parts or 4 parts, as the case may be: facts, explanation, whatever you want to write. So provision, then explanation or fact, and then conclusion on the given cases that Mr. Murthy can claim damages for the personal inconvenience and hotel charges, but not for any indirect loss, which is or any remote loss, because it's a special kind of damages which he is not that private limited company is not supposed to bear. So understand, he is responsible for which loss? He is responsible only for the inconvenience cost which is arising in the naturally in a usual course of business, and not for any indirect loss, and that's why he is not responsible for any medical losses. The next question, we'll go ahead with the second question. Second question is all about one person company. One person company, Rohan Incorporated, one person company. The memorandum of OPC indicated the name of the brother, his brother, that is Mr. Vinod, as a nominee. So Rohan is incorporated a company, one person company, and Vinod is indicated as his name in the OPC, in a memorandum of that OPC as a nominee. However, Vinod is starting his new business in abroad and needs to leave India permanently. Permanently he is supposed to leave. Due to this fact, Vinod is withdrawing his consent of the nomination from one person company. Now what will happen is, first case, if it is mandatory, is it mandatory for Vinod to withdraw his nomination? And the second, can Mr. Rohan make his 17 years old son as a nominee in that case? So first question, so understand, first of all, this question is for 4 marks. That means 2 marks for this, 2 marks for this. So you're supposed to write accordingly. Don't try to write so long which is not deserving for that given number of marks. That means if you are asking the question 2 marks question, so provision is common, so don't write first, second, provision, provision, then facts, and then conclusion, and don't repeat again and again and again, or maybe provision and conclusion, provision and conclusion. If the provision is same for 1 and 2, write once only, otherwise you will you won't be able to save your time. So first of all, you're supposed to write provision only once in these kinds of questions where provision is same only for 1 and 2 point. So provision here we're supposed to write about OPC. In that, first of all, who can incorporate OPC and who can become a nominee. So if you guys remember, we saw one line out there whenever we were studying. That time, the one person company, for one person company, any person, eligibility criteria was, first of all, he should be a natural person, whether it is a member or a nominee. First of all, he should be a natural person. The second was, he should be the citizen of India, and the third condition was whether he is resident or not, but he should live in India for more than 120 days, but immediately preceding financial year. That was the condition, correct? So immediately preceding financial year. So understand, in this situation we are having provision that, first of all, 120 days immediately preceding year, then natural person, Indian citizen, and resident or not, that person will be eligible to appoint to incorporate a one person company. Plus the second was, that person can be, or any this kind of person, all the person who is fulfilling all these conditions will be appointed as a nominee. So in this situation, because the Vinod will not satisfy the condition, so he is supposed to withdraw, or it is mandatory for Vinod to withdraw his consent, withdraw his nomination. Why? Because he won't be living in India for more than 120 days. And the second was whether the 17-year-old son. Now understand, secondly, Second thing, minor cannot be appointed as a nominee. That was the clear cut given in your section also. So yes, so this is not allowed. So answer will be no, and here the answer will be yes. That yes, he is supposed to withdraw his nomination. Now the question number 1C. Here a straightforward question is there. A breach of condition can be treated as a breach of warranty. If you guys remember, there was one diagram in your module also given in your Sale of Goods Act, that there are few situations where the breach of condition will also be treated as a breach of warranty. Why? Because breach of condition is quite serious as compared to breach of warranty. In breach of warranty, you try to make a liberal your try to make your contract okay with whatever the things are going on, or you accept the flaws of the contract sometimes. Because when it comes to breach of condition, it is something which is serious, and in that situation you get the right to repudiate the contract. But when it comes to breach of warranty, you cannot repudiate, you just can claim the damages. So here, if you are claiming if you are considering breach of condition as a breach of warranty, then there is a something serious thing. And there was 4 situations where we used to do that, given in section number 13. Which were they? First of all, whenever the buyer waives off the performance of the condition, that means he is okay that even though the seller is not performing the given conditions, he is okay with that. So he is waiving off his right. Then second, whenever there is a breach of condition, whenever he can claim only the damages instead of repudiation of the contract, whenever he decide only to claim the damages and not to repudiate or cancel the contract. And the third is whenever the contract is non-severable and the buyer has accepted either the whole or the part of the goods. First of all, it's not severable, that is not separable, plus he has already accepted the part of it or full of the goods. Then in that situation, and the last was because of the impossibility or otherwise, excused by the law by the reason of impossibility or otherwise, because of that the person is not able to fulfill, the seller is not able to fulfill the conditions, then he may, that means buyer may choose to elect or choose or elect that to breach of condition as a breach of warranty. So this is all about the question number 1. So I hope you understand question number 1. The next is question number 2A. The question is for 7 marks almost, so you're supposed to write a lot. Here they are asking, explain the term condition contingent contract, and along with that you're supposed to give all the examples for that, and all the relating provisions of your contingent contract. So understand, first of all, 7-mark questions. So first 2 marks will be for writing what is contingent contract, and the remaining 5 will be all the other points which we were having in our module. So first, what is contingent contract? A contract which is to do or not to do something if some event or collateral to such event does or does not happen, right? It is dependent on something. So if that collateral event does or does not happen, then only your contract may or may not be performed. So this is all about the contingent contract. For example, they have given this example, you may write something else, no problem. But the rules are very important. We have 5 rules, 1, 2, 3, 4, 5. Which are they? First of all, the enforcement of a contract of condition depending on event happening, and the second is on not happening. Okay, in this happening and not happening, you can write this along with the examples also. So first of all, like understand, first of all they have written where a contract identifies happening or future contingent event, the contract cannot be enforced until and unless that event happens, correct? Because it is dependent on happening of something. If that is going to happen, then only you are going to perform that contingent contract, otherwise you will not. So that's why your event is dependent on happening of something, so you will perform only when that event is happening, otherwise you are not going to perform. First of all, the second is not happening means what? The second condition, your contingent contract is based on not happening of certain event. So if that event is not happening, then only you will perform. So 2 situations, one is on happening, the second is on not happening. For example, for happening, if A marries to B, C will give 50,000, or if the ship does not coming on the maybe the 1st of June or something like that, then if the ship is not coming, then only you will be getting money. So if the ship is not coming by 1st of June, then you will get 50,000. So these are just the examples. So these kinds of examples also you can write in your exam. The third is, contract would cease to be enforceable if it is contingent upon the conduct of a living person, when that living person does something to make the event or the conduct as impossible, as a conduct as a impossible of happening. Means what? Understand, impossible of happenings means X promises Y to marry X and Y. There is a contract between Y and Z, that if X marries to Y, then Z will give him money. But because Y is no more, Y is dead, this contract is not going to happen, correct? Because it becomes impossible to perform that contract. So these kinds of contracts can be considered as a contingent contract. And the last two situations where the contingent on happening of specified event within the time specified and specified event not happening within the specified time. So here they are giving a time period along with the happening and non-happening of event. In first 2 points it was only about happening of event, not happening of event. If the time is not given, reasonable time will be considered, but here they are specifying the time and not specifying a time of happening and not happening of certain event. So understand, deciding time but happening and not happening. So fixed time is there, and you will be considering two factors, specified event happening and not happening. So this is all about. And the last point, 6th point, is not 5 points, there are 6 points. 6th point is contingent upon the impossible event. What I said, this example, similar example in given can be given for section number 36, that the contingent agreements to do or not to do anything if an impossible event happens are void, whether impossibility of the event is known or not known to the parties doesn't matter, obviously. So this is all about 6 points of contingent contract. So you can write these and you may get 7 marks. So next is what? Next, this question is quite what I can say, important kind of a question, because this question has been asked for in many of the RTPs, many of the past examination papers, and in mock test also. So this is one question which usually the institute asked, but yes, understand along with this that this time there is an amendment in LLP Act. There are a lot of many new provisions which are been inserted in your syllabus. So this may happen that this time they may ask about amendments, because last time also they had an amendment, but no, only one question is supposed to come in your exam for on LLP. So this may happen that this time they may ask for amendments, but if you are getting one question, you may get the one question, this question only in your exam. What is that question? Limited liability partnership gives the benefit of limited liability of a company on one hand and flexibility of partnership on another hand. So it's basically LLP is nothing but the combination of partnership and company. So company, you are getting the benefit of limited liability, and the partnership you are getting the other benefits. From partnership you are taking flexibility and all the other benefits. So this is the combination. LLP is a combination of these two, and you are just supposed to write or discuss in this. So whenever you are knowing already, they have given the hint is given in the question itself that they are talking about limited liability and flexibility point. So first of all you will be writing limited liability of a company, and then second will be flexibility in partnership. So limited liability, there are few points. The first of all, that any company which is established under Companies Act, it has a limited liability. So that feature they are taking in LLP. So here they are saying that every partner of LLPs for the purpose of business is the agent of the LLP, but not of the other partners. If you guys remember, we have already seen that every board of director is a agent of a company, but not of the members. So similarly here also, every partner in LLP is a agent of that LLP, but not of the any other partner. And that's why we are not jointly and severally liable for the other or liable for the other partner or the conduct of the other partner, which we used to do in partnerships. So now here, understand the first point, you're supposed to write this line, and the second thing which is given under section 26 of LLP, and the second line is the liability of the partners will be limited only to the contribution. They have agreed for some contribution only towards that. they are liable to the extent of their assets they are holding in the partnership, in the LLP, otherwise no. So first that, and the second is flexibility of a partnership. Flexibility is nothing but they are talking about internal structure, that they are mutually there is a mutually agreed agreement, arrived agreement. Then secondly, it because of the, if you write these lines, still it's okay. If not, you can write flexibility points like the partnership, they are mutually agreed contract or the agreement among them, and they are acting for each other, and they have quite they are not following that stringent laws which company is supposed to follow according to Companies Act. And you may write like that also. If you are writing these statements, that's okay. If you are not able to write, then still it's okay. The next is question number 3. Define the partnership and elements. Now they have given the distribution of marks also, 3 and 3. So first of all, defining partnership, you will get 3 marks, and then writing essentials and defining partnership and elements, you will get 3 marks, and defining out of these elements any 2 elements will give you 3 marks. So first of all, partnership, you're supposed to write section number 4, that definition, that partnership is nothing but the agreement between 2 or more persons. If you guys remember, we have discussed these 2 lines for almost an hour. So 2 or more persons, we have discussed on this. 2 or more persons who have agreed to share the profits of a business, whether carried on by all or any one of them acting for all. And what are the elements? First of all, 5 elements. First, business or agreement, association, business, sharing of profit, and mutual agency. And out of these five, carried on by all or any one of them acting for all, you can write anything, any 5 points. And now they have given whatever is given in your module, they have given all the 5 points here. You're supposed to write any 2 out of these 5. If you ask me which 2 points we're supposed to write, then I would say whichever the point you feel that you are good with, you supposed to write that point. Okay, so I would suggest that association is quite easy, where you can mention the section also. So whenever you get the chance to quote a section, try to write that. So here in association, you get a chance to quote a section number, so you may write that. Agreement is okay kind of a point. If you want to write, that's okay, but the quite difficult point again is either this one or this one. You choose any of the points. So first of all, whenever you talk about the association, first of all, it's partnership is the association of 2 or more persons. Then secondly, the 2 or more persons who have the status or the legal recognition in the eyes of law. That means 2 partnership cannot enter into a partnership, if you guys remember, but the body corporate and 1 individual can enter into a partnership. Then third line, you can write this section 464 and the limit of 50 partners. This much you can write in first point, that is association. The second is agreement. Agreement can be oral, written, it could be express, implied, it could be anything. So this much is important in agreement. Business means this definition is given in Partnership Act, that is, business is nothing but it includes every trade, commerce, occupation and profession, and the motive, any business should be only and only for the purpose of earning a profit, not profit organization. For not profit purpose, you cannot form a partnership. So there has to be a profit sharing, there has to be a profit earning motive while forming a partnership. And the next is partnership, sharing the profits. If the profits they have, whatever the partnership did they have, they can either mention their partnership profit sharing ratio. If not, then it will be equal. Then along with the partnership profits, we consider the losses as well. Profit word includes the losses as well, and unless otherwise agreed, that means this is also possible that one partner is admitting or coming only for sharing the profits and not for any loss. This is also possible. So unless otherwise agreed, the profits includes loss word as well. And the last one talks about the mutual agency principle between the partnership, that is the cardinal principle of partnership law. That's why I said either write these kinds of words which are quite important or the keywords in your exam. So I would suggest that write first one agree that 2 or more persons association point, and the last one 5th point. Now that's it. About this, the next question number 3b. Kapil went to a departmental store to purchase a steel pan, and he asked a salesman about the area of the departmental store where steel pans are kept. Okay, so he is asking about what area in the departmental store where the steel pans are kept. Now the salesman indicated him the area with the instruction that with the steel pans and the other metal pans were also kept. Now Kapil wrongfully picked the aluminium pan and in place of steel pan, wrongfully. Now the salesman watched, but he did not. But he said nothing to Kapil. Kapil reached his house and found that pan was not of a steel pan, but it was actually aluminium. Kapil filed a suit against the departmental store for directly fraud. Just by choosing the different pan, they are filing a case of fraud. Now, whether this suit is maintainable or not, you're supposed to write. So, understand first of all, Kapil is going in a departmental store and taking that pan, and they are filing a case under the head of fraud. So, first of all, you're supposed to write about fraud. So, section 17 talks about fraud. So, section 17, fraud means what? Fraud means and includes. The definition is all about means and includes any of the following things. First of all, any suggestion as a fact of which is not true by one who not believe it to be true. The second is actively concealment of a fact. Second is promise made without any intention of performing it. Any act which is fitted as a deceive act. And the last is any omission by the law which declared to be fraudulent. So here 5 points are given, means and includes definition of fraud. 5 points which we already discussed just now. Now it is also explained that mere silence is also not a fraud. Sometimes silence amounts to fraud, but in some situation mere silence does not amount to a fraud. In this case, given situation according to section 17. Now understand this much, whatever they have given, this much, this all included under the head of provision. They haven't given the explanation or justification. You may write 1 or 2 lines of explanation or the facts, not justification, explanation or the fact, whatever the question is all about. And then last, you're supposed to write section 17. According to section 17, it was not the duty of a salesman to inform Mr. Kapil about his mistake. There was no fraud, as the Kapil was negligent about the given situation, because he was negligent. He did not choose the right pen. So for this matter, salesperson will not be liable at all. So this is not a fraud case. So this is the conclusion part, and the other was the provision part. I hope you understand. The next question is question number 4. We will discuss the rights of the unpaid seller. Straightforward question. Rights of the unpaid sellers for 6 marks. Rights for the unpaid seller or buyer. The right of unpaid seller against the buyer. Okay. Discuss the rights of unpaid seller against the buyer. So here against the buyer. So we have 2 types of rights. One was against the goods, against the whatever the property which is involved. Property in Sale of Goods Act means the ownership basically. So whatever the asset is involved, against that you will be having some right, and against the person or the buyer you will be having some rights. So we supposed to discuss about this and not about the right of lien or right of stoppage in transit. We are not going to discuss about that, because they are the rights which are against the goods. We are going to talk about the rights against the buyer. The first right will be suit for the damages, suit for the price first. So obviously that person is becoming unpaid seller, so he has a right to recover that price. But in 2 kinds of situation. One situation where the property in goods has been passed, that means ownership is passed, and the second is where the ownership is not passed. So in this first situation, where the property in goods has been passed to the buyer and buyer wrongfully neglects or refuses to pay the price, then seller will sue him for the price. And the second situation, where the price is payable on certain irrespective of delivery, the buyer wrongfully neglects or refuses to pay the price, the seller may sue him for the price, although the property in the goods has not been passed. So whether passed or not passed property, passed or not passed, doesn't matter. You can directly file a suit against that buyer for a price. The second situation is obviously, but buyer supposed to wrongfully neglect or refuse to pay the price, then only. The second is second right you have is suit for damages for non-acceptance. That is, buyer wrongfully neglects or refuse to accept or pay for the goods, then you can directly claim for a damages. The third is repudiation of a contract before the due date. This is all about the anticipatory breach of contract, if you guys remember. So this rule is anticipatory breach of contract. If you believe that this contract is not going to perform, you may resign, that means cancel the contract. And the last is to pay for the interest. Interest will be from the due date minus from the due date to the payment date. Whatever the number of days we have, you can claim interest for that. This interest rate can be decided by the court also, or as whatever the mutually decided in the agreement. So these are the four remedies or the rights which are available with the unpaid seller against the buyer. Now let's go ahead with the next question. Next question is question number 4B. Mr. M is one of the four partners in MSS X and Y enterprises. He owns sum of 6 crores to his friend, to Mr. Z, which he is unable to pay on due date. So what is happening? Understand, there is a partnership of Messrs XY. Okay, this is a partnership. Now there are four partners. One partner is Mr. M. Mr. M is one of them. He owns sum of rupees 6 crore to Mr. Z, which he is unable to pay on time. So he wants to sell his share in his firm to Mr. Z for settling his account. That means he wants to sell his share to him. Selling shares. That means transferring share. Selling the shares. Now can Mr. M can validly transfer the interest or sell that share? And secondly, what would be the rights of transferee in case M wants to retire from the firm after a period of 6 months from the date of transfer? So this question basically all about the section number 29, if you guys remember, transferring his partnership interest. So transferring his partnership interest, section 29 talks about two things. The first thing, so here they have given the provision part. So provision 2 points were there. Obviously, if you guys remember, 2 points were there. Whenever you are admitting somebody as just as a transferee, but that person will not be becoming the partner in the partnership firm, first of all. So he cannot enter or participate in the conduct of the business. He cannot access the books of account. He cannot inspect the books of accounts. These rights have not been given to the transferee, because he is just entitled to receive the share of profit or the share of asset in case of retirement. But in case of retirement, there is one more provision is there. In case the firm, first understand, whenever the partner is transferring his interest, either absolute or by mortgage. If you guys remember, I have already told you, either absolute or by mortgage means what? Or by creation of charge on such interest does not entitle the transferee during the continuance of the firm to enter into conduct of the business, to require the books of accounts, to inspect the books of accounts, he is just only receive the share of the profits, and he cannot ask for the any books of accounts where to go and check whether the profit share is right or wrong. He cannot check that. He cannot inspect that. So he is this was the first situation. But the second situation is, but in case if the firm is dissolved, the transferring partner cease to become a partner now. Now transferee is entitled as against the remaining partners to receive the share of asset in his firm of the firm, and to which the transferring partner is entitled, and for this purpose, ascertaining the share, he can ask for the books of accounts as from the date of dissolution. So in case of retirement or in case of dissolution of a firm, he can ask for, only in case of dissolution of a firm, he can, like if after the retirement firm is going to dissolve, then, or either whenever the firm is, that transferring partner, that means transferor, is going to cease to be a partner, then only in that situation the transferee will get the right to inspect the books of accounts to check whether he is getting the right share of assets or not. So these are the two situations. In the original situation he cannot. The second situation, in case the dissolution, then yes, he can. So in the first situation, the first question was, can Mr. M validly transfer his interest? Then the answer will be yes, 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 according to section 9, yes, he can transfer his interest, but because of the retirement, he will receive the asset of shares. He can even check the books of accounts also. So in the second situation, yes, on the retirement, he is entitled to receive his share up to the extent of the value of 6 crore in the firm's asset. So in both the situation, the answer is yes. And this question was all about the section number 29. Now let's go ahead with the question number 5. Question number 5 is on the Sale of Goods Act. It talks about Sohan is a trader selling a wheat. Binod comes to his shop and asks Sohan to show him good quality of wheat. Now Binod is satisfied with the quality of wheat. So he is a seller. He is a seller and Binod is a buyer. Okay, he is satisfied with the quality of wheat. Now Sohan agrees to sell 100 bags of wheat to Binod on 10th of June. 10th of June was the date of performance. Now delivery of wheat and payment was made in the next 3 months. That means selling on credit by the 10th of September 2021 by Binod. Before the goods are delivered to Binod, Sohan gets the another customer, Vikram. So he is getting the next customer 2 to his shop, who is ready to pay higher price of wheat. Now Sohan sells goods of Binod to which were already lying in his possession. His possession means whose possession? Sohan's possession. That means seller's possession. In seller's possession to Vikram, because he is paying more price. Now according to Sale of Goods Act, you are supposed to decide whether this sale is valid or not. Now understand, the first of all here the question comes as that you cannot sell something which you for which you don't have right, correct? So if you guys remember, Nemo that code non-habit given under section 27, that no man can sell the goods or give the good titles unless he is the owner of the goods. You cannot transfer something which you don't have. So if you don't have the ownership title, you cannot transfer, correct? Or you cannot sell, sorry, I would say sell rather than transfer. So you cannot transfer, but there are certain exceptions given in this for this rule. So the exceptions are, first of all, understand, whenever the sell is according to no man can according to section 27, then in that situation, sell by the seller in the possession of the goods even after the sell is made is held to be valid in exceptional situations. And which are they? The first of all, after fulfilling the following condition, the first of all, seller must be in the possession of the goods. The second is with the consent of the other party, that is the buyer. The third is the seller sells the goods already sold to the new buyer. The fourth is new buyer acts in a good faith. New buyer in our example, Vikram. So new buyer is Vikram. So Vikram has bought this in a good faith. This good faith word is very, very important. This good faith word only change your answer. So good faith, and the new buyer, that is Vikram, has no knowledge of the previous sale, or the seller is not having any authority to sell. So he is not aware. So he is an innocent party. In this situation, Vikram will get a good title, but what happens, understand, in the given situation. So here this much is all about writing a provision part. Now here they are giving a facts of the case. In the given question, the seller Sohan has agreed to sell the goods to Binod, but delivery of the goods were pending only. So delivery is pending, but he has already sold the goods. Hence Sohan is in the possession of the goods and with the consent of the Binod only. So first of all, he is in the possession. That means seller is in the possession, but that possession is with the consent of the buyer only. That means with the consent of the Binod only. Now Sohan sells the goods to the Vikram, and Vikram is buying this in the good faith without having any knowledge of previous sale. Now since all the conditions of 31 has been satisfied, Sohan and Vikram sale is a valid sale because that person has, the third party or the Vikram has bought the goods in a good faith without having any knowledge of the previous sale. So that's why this sale will be considered as a valid sale. This is your conclusion part. I hope you understand. This is your conclusion part. So next question, we'll go ahead with the last four questions are pending. So we'll go ahead with the next question. Question number 5B. ABC Limited was into the sell and purchase of iron rods. This was the main object given in the memorandum of association. Now the company entered into contract with Mr. John for finance related works, and now later on the company repudiated the contract as being ultra vires Act. Now, according to doctrine of ultra vires, you're supposed to write the consequences of this. So, ultra vires, if you guys remember, ultra vires means beyond the powers, correct? So, this beyond the powers rule means what? That your company cannot cannot go beyond its powers, because memorandum and articles are kind of a public documents. The second thing, the person who is entering into a contract has a duty to check that memorandum and articles, and then only enter into a contract. Now, what is happening is, according to the one of the object clause of memorandum of association, understand, it is already given in the object clause, because it's a fundamental rules of the company. And now what happens is, in the given situation, yes, this is the doctrine of ultra vires, this is the public document. See, this much part is all about, the provision part. Now, you should not write all the points, right? Copy paste it. Okay, so you're supposed to write only key points from here. So first of all, it's a public document. The second first line should be the beyond their powers. The second line, memorandum is a public document. The third line, on the ultra vires transaction, neither you can nor you can sue on it. That means, because memorandum is a public document, the other contracting party must read it, and then only it is presumed that the other party has the knowledge of it. So it was already a presumption. So this power, so all the ultra vires act are always a void acts and cannot be ratified even by the unanimous consent of all the shareholders. So these are 4 lines which were very, very important. Along with that, if you want to write any 1 or 2 lines from this, that this is void, inoperative in law, and not binding on the company, you can write these 4-5 lines only and only. Don't write copy paste kind of a thing in your exam. Then next is, hence in the given case, obviously ABC Limited cannot enter into a contract with the outsider, because it's obviously outside your object clause of your memorandum. So this act will be null and void, because it's your beyond your powers. So this much you supposed to write. The next is question number 6A. This is quite important also. So understand, either indoor management or ultra vires act, you are going to get one question on any of these 2 doctrines. Out of these, any of the 2 things, you will get one question in your exam. So in mock test they have given ultra vires, in RTP they have given both. So you will be getting one of the question. So be prepared for that. The next very important concept or the question is basically on the supervening impossibility. Supervening, there are 2 types of impossibilities. One is initial, and the second is supervening. Initial means from the beginning itself it is not possible to perform that contract. Supervening means whenever you are forming you are entering into contract, it was a valid act or valid things were there, or everything is okay, but afterwards, after some time, it becomes impossible to perform that contract. That means supervening impossibility. So supervening impossibility, you can write whatever the example you want to write, but the only important words are when the performance of promise becomes impossible or illegal because of some events, or because of some law or the contemplation of the party, it becomes void. Void word is very, very important. All the supervening acts becomes impossible, and this impossibility or the post contractual impossibility, also we can call it as a post contractual impossibility. You write example, whatever the example you want to write. X and Y decided to marry, Y is no more, Y is dead. So this contract becomes impossible contract, supervening impossibility. So this will be void contract. And effect of impossibility, always void, because, and the contract will get discharged because of impossibility to perform. The next is the question number 6B is subject to the agreement by the partners. State the rules State the rules that should be observed by the partners for settling of the accounts on the dissolution. So this was basically all about the section number 48, how you settle down the dues. So there is some what you can say sequence which is given to pay off your all the liabilities. Whenever you are paying off your liabilities, you are supposed to follow this sequence. The first of all the law, it was observed that the losses, see, According to section 48, your account should be settled down in the following manner. First of all, you understand whether there is a profit or a loss. So loss, deficiency of capital shall be paid only out of the profits and not out of the capital. That means you're supposed to pay the outsiders first, and then only you will pay to the remaining amount you will be paying to the partners. So while following the sequence, first you're supposed to pay off the debts of the third parties, then paying to each of the partners ratably what is due from him, due to him from capital. Then after that, in paying to each of the partner ratably what is due to him on the capital account, and last, if anything is remaining, then share it as a in your profit sharing ratio. So it's basically like companies pay first secured or the outsider one, and then what if there is something remains, then only the partners or the members or equity shareholders will get something, so residue. And this is because this line that any of the loss or the deficiency in the capital should not be paid out of the capital only, it should be paid only and only out of the profits, first out of the profits only. So this is all about section number 48. And the last question is, Mr. Raj formed a company with a capital of 50,000. So Mr. Raj forming a company of 50,000. Mr. Raj formed a company whose capital is 50k. Okay. Now he sold his business to another company. He's selling his business, this 50k business to another company. This business is to another company. Now, but this is for another company. This is for 40k. Now, payment of the sale, he accepted the shares worth rupees 30,000 and the balance 10,000 he considered as a loan. So this 40 was divided into 30k as a 30k and 10k. This is as a loan and this as a shares in the another new company. Now what happens? The balance as a loan, Mr. Raj secured the amount by issuing the debentures. So there was a secured debentures. His wife and 3 daughters took 1 share each, and owning the strikes of the company was wound up. The assets of the company were 6,000, valued at 6,000. Now this company, this business is going in a winding up. Now what is happening? The assets valued 6,000. Asset is 6,000. Assets worth 6k, and unsecured creditors worth 8k. Now Mr. Raj retained the entire 6,000 as a part of his loan account to this, and the other creditors objected. Their contention was it could not be his own money, and the entire sum of 6,000 should be paid to them, to the unsecured creditors. Now whether the contention was right or not, understand first of all, the 30,000 or the issue was against the secured debentures. So this was a secured debentures. Okay, this was secured debentures, not shares, the secured debenture you should say. Now secured debentures, but this loan was not secured one. This loan was not secured one. Now what is happening is they are Mr. Raj is taking this 6,000 assets and applying it against the loan amount. Now what will happen? Understand. First of all, separate legal entity case. You're supposed to understand that members are different and company is different. Famous case law of Salomon and Salomon Company, Salomon Company Limited. So whenever you are paying off the debts of the company, you should be seeing that lifting up of corporate will. You're supposed to check whether they are paying to the members as in the capacity of a member, or paying in the capacity of a creditor or the outside party. So in this given situation, in the given situation, the company is distinct and members are different. So based on the given provisions, Mr. Raj was entitled for the assets of the company as he was the secured creditor of the company, and one second. This was also secured. Okay. Mr. Raj secured the amount also. So this was also secured one. So obviously, first of all, you're supposed to pay to the secured creditors only, and then only to the unsecured creditors. So unsecured, even though Mr. Raj himself is the owner, or working in the having a secured debentures, but along with that he is a secured creditor also. So first of all, you're supposed to pay to the secured creditors, and then only to the unsecured creditors, then only to the members of the company. And in given situation here, understand this person is have secured his loan amount. So this 6K he can directly apply and he can succeed because remaining creditors are unsecured creditors. So that's why first he will get the priority over the unsecured ones. So here is all about the law mock test. Now second video will be about all about the mock test 2 for law. All the best. Take care. Keep studying. Keep revising.